Good afternoon, everyone, and welcome to today's seminar. It brings me great pleasure to introduce Dr. Ed Johnston, who is Associate Professor and Research Lead at University of Northampton. Dr. Johnston specializes in criminal justice, and he's been doing some really fascinating empirical research in this area, particularly at the pre-trial stage. So we have invited him to join us in Hong Kong for a short visit. This is the first of two seminars. The title of today's seminar is The Perennial Problem with Disclosure. Perennial Problem. I once gave a training seminar for prosecutors in Hong Kong, and I used the title worst part of the job, because that is how I felt when I was a prosecutor in Ontario. That we would constantly get these disclosure requests. You'd have to chase after the police to try to meet the request, because of course it's very important, because we know that if you fail to respond, it could well be the subject of an issue at the trial. So Dr. Johnston, thank you for being here with us to talk about the issues facing England and Wales. The floor is yours.
I'm delighted to be here. Is that better? Cracking start. Thank you, Professor Young. I'm delighted to be here today. I'd like to thank the Centre for Comparative Public Law for hosting my talk and for Professor Young for inviting me. I'd also like to thank Flora, Phoenix and Victoria for all their help with the organisation of my travel and accommodation. So as Professor Young says, I'm an Associate Professor of Criminal Justice and Procedure at the University of Northampton, and my research interests lie in the pre-trial stage, in particular, disclosure and fair trial rights. Our disclosure regime is very different to what you have here in Hong Kong, and I'm going to talk through some of the pitfalls that we have in England and some of the issues, some of them. I've only got 40 minutes or so I can't list them all, but there are many. So the Royal Commission on Criminal Procedure reporting in 1992 said that the adversarial system needs to rid itself of excess, i.e. it's too bloated, it's cumbersome, and it's slow. And ultimately, the system needed changing. The Commission themselves were subjected to a number of criticisms, and I won't discuss them today, but it's the start point of a transition period. It's still ongoing today that sort of changes our system from an adversarial system, the traditional adversarial model, to something that's far more managerial in nature, based on cooperation between both the prosecution and the defense, as well as trying to make things as efficient as possible. The two major changes that came out of the back of the Commission were the changes to silence from the Criminal Justice and Public Order Act in 1996, and then swiftly followed by the defense disclosure regime created by the Criminal Procedure and Investigations Act in 1996. The purpose, as I said, of the changes was to make everything more efficient, more effective, and more economic. We are trying to save money and make the system faster. But ultimately, I don't think you can put a price on justice, and I think we've gone too far in the managerialist direction. So disclosure in England and Wales is a relatively new creation. There was no rules for any disclosure until the 1940s. There was no duty on either side to disclose any information to the opposition. The case of R and Bryant and Dixon in 1946 is thought to be one of the starting points of this idea of disclosure. And it was changed, and it was sort of enhanced and made clear that disclosure is important in Dallison and Caffrey in 1965, where Lord Justice Denning said it would be reprehensible for the prosecution to conceal a witness that they know can give material facts to the defense's case. For Denning, the idea around disclosure was based on the spirit of what you're trying to achieve and not necessarily the letter of any particular law. For Denning, it was about evening up the inequality of arms between the prosecution and the defense. The prosecution have an investigative body, i.e. the police, to conduct pre-trial investigations. The defense do not have that luxury. As such, if the prosecution knows of information that will assist the defense case, it would be reprehensible to conceal that. And if disclosure stops there, with that idea in mind, I would have no interest in it, wouldn't have a PhD, and I certainly wouldn't be here today. However, it didn't. So although this was the start of the disclosure regime, there was still no duty for the defense to disclose any element of their case. That changed in 1967 with the first foray into defense disclosure by disclosing alibi witnesses. The name and address of the alibi witness, or if that's not known, any information that can help the police identify that particular witness. This was followed in 1987 with a disclosure of expert evidence. If you're using an expert evidence, if you're using expert testimony, you have to disclose that to the prosecution. I don't think either of these issues are contentious. I think they're fair. And again, I don't think that those pose any problems whatsoever. Neither element ought to be problematic. However, the Criminal Procedure and Investigations Act created in 1996 created a seismic shift in how we do criminal justice in England and Wales. This, in my opinion, is the catalyst for the rise of managerialism, and it comes at the expense of adversarial due process values. Arguably, it offends the privilege against self-incrimination. There's issues around silence as well. But it was designed for efficiency saving. It underpins the disclosure regime that we can be quicker resolutions, better for everybody, and we are saving money. And this needed to be done because the original regime held this significant disclosure obligations for the prosecution. It was heavy. And the commission suggested that the defense were conducting fishing expeditions where we were asking the prosecutors to find information, but the purpose of this was to cause delays, which might eventually lead to the prosecution dropping the case. So the CPIA sets out for the first time a statutory framework for disclosure in criminal cases. And it started with a three stage test. It was reciprocal in nature. Section 3.1, the prosecutor must disclose any prosecution material which has not been disclosed to the accused and might reasonably be considered capable of undermining the case for the prosecution or assisting the case for the accused. It's a relatively simple test. That's all the prosecutor has to consider. So that's the first stage, section 3.1. Then we have section 5, where the defense produces a defense case statement based on this initial disclosure. And once this had been considered, it would trigger the secondary stage of disclosure under section 7, where the prosecution will then go back and look at their evidence and disclose things that might not have been disclosed prior to seeing the defense case statement. So it's 3 stages. The Criminal Justice Act 2003 thought this isn't working, so it changed, and primary and secondary disclosure stages were changed for an initial disclosure obligation from the prosecution and then a continuing disclosure obligation. So the defense case statement, I said that this was created a seismic shift in criminal justice, and it's pretty broad in what needs to be covered. Bearing in mind, prior to this, outside of alibi and expert evidence, the defense didn't have to disclose anything at all. So the first thing that the defendant has to disclose is the general nature of their defense. They have to tell the prosecution of matters that they take issue with in terms of the prosecution case. And they have to explain the reasons why they take issue with the prosecution's case. And if you are using an alibi or any expert evidence, that needs to be disclosed as well. So it's quite broad in terms of what the prosecution are expecting, and the court would frown upon defense lawyers who submitted defense case statements with minimal information on. If it's vague, it's not going to suffice the court. You have to be precise. And again, in the interest of efficiency, once the defense has received the initial disclosure from the prosecution, the defense has 28 days to file a defense case statement. This is only mandatory for trials on indictment, trials that are heard, cases that are heard in the Crown Court. For cases that are heard in the lower court, the Magistrates' Court, this obligation was voluntary. But that wasn't enough in terms of our drive for efficiency, and the 2003 criminal procedure rules effectively mandated disclosure to be mandatory in the Magistrates' Court as well. And that's from the case management forms of the rules. The rules came around because of Lord Justice Old's 2001 review of the criminal courts of England and Wales, and again, reiterated the findings of the RCCJ in 1992, that there's too much waste in our adversarial system. It needs to be more efficient. It suggested a consolidated set of rules, and the criminal procedure rules, for the first time in England and Wales, gave an overriding objective of what all cases have to do, and it's to deal with cases justly. And this overriding objective is pretty broad. I won't go through all of these parts, but for the first time in any consolidated set of rules or in any legislation, we have the goal of dealing with the case efficiently and expeditiously. So the case management forms are very similar to that of what's expected in the defense case statement. And this is now mandatory in all cases. Rule 3.2 says the defendant must identify the real issues in the case. And this is very similar if you look at the form and look at the defense case statement as well. It's very similar to each other, the idea of identifying the general nature of your defense. The rationale behind this was to ensure that progress in trials were made and stopping delays. The evidence or any evidential disputes were resolved and presented in the shortest way possible, the most efficient ways we can. As I say, this is now mandatory, and ultimately it tries to foster a culture of cooperation between the defense and the prosecutor to achieve the overriding objective of dealing with the case justly. But I think it's distinctly non-adversarial in nature. And I think it questions whether or not we can uphold the presumption of innocence if we are asking defendants to complete these efficiency forms. The same goes for the privilege against self-incrimination. And we had an issue in 2011 in the case of Firth and Epping Magistrates' Court. The prosecution in this case, it involved an alleged assault on a train platform in Epping, which is just outside of London. The prosecution could not produce any evidence that the defendant was at the scene at the time the alleged offence took place. However, her case management form suggested when identifying the real issue at play here, the defense lawyer said self-defense. And the prosecution sought to rely on this case management form to produce evidence at the scene. And the court allowed it, and Firth was convicted. We had a case that shortly followed this, the case of Newell in 2012, that tried to follow the same suit, relying on this efficiency form as evidence. And the court said, well, no, we can't have this if as long as the defense are playing by the spirit of the criminal procedure rules, we will not allow these forms to be introduced as evidence. However, it's a relatively opaque wording, And it suggests that if the defense are not abiding by the spirit of the rules, their client can be punished and these forms introduced. As of yet, that hasn't been the case. We also have the Attorney General's guidelines on disclosure with the latest version published in 2021, which illustrates how disclosure ought to be done in England and Wales. And interestingly, how this talk will follow on to my talk next week. This introduced the concept of pre-charge engagement, which was tacked on in an appendix to the rules. And I'll go through that next week. But pre-charge engagement and disclosure are inextricably linked. It says that disclosure ought to be covered or ought to be completed in a thinking manner. And what that means is it's taken from the case of Aluwalu, Wilson and Brooks, where not undertaking the process in a mechanical manner, keeping the issues in mind, being alive to countervailing points of view, considering the impact of disclosure decisions and keeping disclosure decisions under review. Ultimately, re-emphasizing the fact that disclosure does not happen in stages. For the prosecution, it's a continuing duty that runs through the duration of the investigation and the case. So the prosecutors need to think about disclosure at all times. But as we'll work through the research momentarily on disclosure, it doesn't work. But remember, it's a relatively simple test of when disclosure ought to be made. Any evidence that assists the case of the defense or undermines the case for the prosecution. If that's the case, disclose it. So, what happens if you don't comply with your disclosure obligations? Well, the court take this relatively seriously. And the court or any party making such comment as appears appropriate if the accused does not do any of the following: fails to provide a defense case statement, fails to mention something in the defense of the statement that he later relies on at trial, fails to give an account at trial that is inconsistent with the content of the defense case statement. And that's section 11. So what this means is the court can draw an inference as to why the defendant would be lying, why there would be this inconsistency. So if you think about it, the defense case statement makes up the bedrock of the accused's defense. So it's imperative that that form is completed properly. However, for that form to be completed properly, you need adequate disclosure from the prosecution in the first instance to build your defense case statement. Without that, it's impossible to, or it's difficult and it's unfair to expect the DCS to be served within 28 days. But what about non-compliance for prosecutors? Because all you hear in England and Wales is, it's the defense that are causing delays. They are gaming the system to get the prosecution to drop the case. And when you look at the number of ineffective trials, that's trials that start but then aren't completed for a number of various reasons, but the metrics are counted with prosecution disclosure issues and defense disclosure issues as well. Those numbers are broadly the same, but it's constantly the defense who is being hit with the stick to say they are failing, they are doing this wrong. So what sanctions for non-compliance of prosecution disclosures are there? Well, there's wasted costs orders, but these are relatively rare. There are cases that exist with this, the case of Singh, the case of SBS solicitors as well. They do occur, but ultimately it's relatively fruitless. You are moving money from one public body to another. There is no real punishment there. But the court were very clear in Singh that the court is not bound to make an order in every case of a mistake. So we have this question of, well, how big does the mistake have to be for the court to make a particular order? I think one of the sort of better approaches would be sort of professional censure or suspension for continual failings with your disclosure obligations. And this occurred very recently, within the last 18 months. A QC named Timothy Raggett was suspended for 12 months for lamentable disclosure failings in a number of cases. So in pockets, courts take a very hard line against prosecutorial failures, but in general, not a lot happens before the disclosure failure. So what about the research that's been conducted on disclosure in England and Wales? Does it work? The short answer is no. This is taken from a review of the disclosure regime taken in 2001 by Plotnikoff and Wolfson, and they found that information disclosed by the police to the prosecution was often incomplete and of poor quality. 2/3 of prosecutors said they had insufficient time to review the disclosure schedules that they received from the police and then make their disclosure decisions to the defense on the basis of that. They don't have enough time. Many prosecution barristers that spoke to Plotnikoff and Wolfson did not support the underlying principles of the CPIA and the disclosure regime. They thought it was unadversarial. 54% of defense the defense case statements fell short of the statutory obligations. They were insufficient. 61% of judges were dissatisfied with the way the disclosure regime was working. They say that's from a fair balance in 2001. So almost immediately, 5 years after the inception of the disclosure regime, it's clear there's an evidential background to say it's not working. And things haven't got much better over the case of the last 20 years. In 2017, we had the Making It Fair, a joint inspection of the disclosure of unused materials in volume Crown Court cases. And it found that the inspection found that the police scheduling of evidence that will go into a disclosure schedule is routinely poor. The revelation was made by the police, the revelation made by the police to the prosecutor of material that may undermine the prosecution's case or assist the case of the defense, i.e. stuff that would satisfy the disclosure test, is rare. And if you think the police are the gatekeepers of this information, they're the ones that hold all the information, they have to schedule it. So if it's not occurring at the police station stage, the system cannot function because the foundation is too weak. Prosecutors then fail to challenge poor quality schedules and in turn provide little or no input to the police. The failure to grip disclosure issues early often leads to chaotic scenes outside of courtrooms where last minute and often unauthorized disclosure between counsel, unnecessary adjournments, and ultimately discontinued cases are common occurrences. This isn't immediately after the disclosure regime came into force. This is 21 years later, after we have a regime of compulsory statutory disclosure. It's clearly not working. The Mountcher investigation looked at you might have heard of the case of the Cardiff 3 or the Cardiff 5. The Cardiff 5 were 5 individuals who were accused of the rape and murder of a prostitute in South Wales in the UK in the early 1990s. 3 of the defendants were convicted and became known as the Cardiff 3. Eventually, there were a raft of issues around disclosure, DNA evidence, and a myriad of other issues that led to their acquittal, notwithstanding the fact the actual murderer was identified and later convicted. But the Mountcher investigation looked at the conduct of the police throughout the course of the Cardiff 3. And it concluded the following. Poor management by the Crown Prosecution Service. Sorry, the Mountjoy investigation was about the investigation into the conduct of the police officers who stood trial in 2013, which collapsed because of disclosure failings. And the investigation, the report suggested poor management by the CPS at the beginning. Too narrow a disclosure test was applied. An inability to retain disclosure officers, a lack of instruction to police officers of how to deal with sensitive documents, and a lack of appreciation of the significance of disclosure. Now, at the risk of repeating myself, disclosure is the bedrock, the foundation of just criminal procedure in any jurisdiction, but in England and Wales in particular, where we have this statutory regime. And if it can't work, we can't have just outcome. You may have heard of the case of Liam Allen, which was a massive disclosure issue in England and Wales. Liam Allen was a white 19-year-old student who had been charged with 12 counts of rape and sexual assault in 2015. 3 days into his trial, it was discovered that there were a raft of mobile phone text messages from the complainant indicated that the sexual intercourse they had was consensual. One message from her phone read, "It wasn't against my will or anything." Now, this wasn't disclosed. The defense asked the prosecutor in the first instance, is there any mobile phone data that passes the disclosure test? The defense was completely told no, that there is no evidence. Jerry Hayes, the prosecuting barrister, pushed this a little further, and he was the one who discovered these disclosure failings. It was him, the prosecutor, that discovered this. It was one evening, 3 nights into the trial, and then had to call the defense to say, there's likely the case is going to be dismissed tomorrow because we found this. Now, this was a massive case. In the fallout of this was massive. But even before we get to the fallout of this, the inadequate disclosure led to, obviously, Liam's legal advisor suggested a plea deal that was offered to him by the prosecution. I had Liam come to my old university at home to discuss his case. And he said, we asked about whether or not there was a plea deal. And he said, yeah, the prosecution offered me 9 years in prison and a lifetime on the sex offenders register. So signing the sex offenders register once a month, once a week, something like that. And he said he contemplated it. This was he lived with his mother. She was struggling with all of this, and he contemplated 9 years. And he said, if it wasn't for the fact of having to sign the sex offenders register for life, he may well have been inclined to take that deal. Also, he spoke of the pressure of the case on his own well-being as well. He spoke of, he was in the bath one evening contemplating suicide. And this all could have been avoided by adequate disclosure at the start, competent disclosure at the start. Parties in the case taking their duties seriously. It should not get to 2 years after the allegation, 3 years into a court case, 9 years as a plea deal being offered, before we find there is information that undermines the case for the prosecution or assists the case of the defense. It's unfathomable that this happened. None of this was disclosed. The case was eventually dropped the following day on day 4. However, the case was not logged as a disclosure failure. I was interviewed by the Observer newspaper in England around issues around disclosure. And when I was reading and researching the issues in this particular case, the chief prosecutor in England and Wales claimed to a parliamentary body that this case was not logged as a disclosure failing. So I think that the number of ineffective trials that we actually see logged because of disclosure failings is only the tip of the iceberg. Because if the biggest case in recent memory isn't logged as a disclosure failing, I think it's safe to assume that this happens day in, day out, up and down cases that collapse in England and Wales. So what happened in the aftermath of Liam Allen? Well, immediately the Crown Prosecution Service announced that it was assessing all cases in England and Wales where someone had been charged with rape or a serious sexual assault. The review process included an assessment of 3,637 cases. So not large by any stretch, but not small either. Over a 6-week period, how many cases do you think, in only 6 weeks, does anyone want to take a guess of how many cases the prosecution service found where there was an issue in disclosure? We're talking 40-something days. Anyone brave enough to guess? Just like my students at home, nobody ever wants to talk. Sorry? A third. Not quite a third, but more than one a day. 47 cases between the 1st of January and the 13th of February found that there were 47 cases where an issue in relation disclosure had stopped the prosecution. This problem is rife. It's a massive problem in England and Wales. So with this in mind, we have now made our mistakes with the Mountshire report. We've made our mistakes with the Liam Allen case. We ought to be doing it better. No, we're still not getting it right. 2018, our review concluded that although the CPIA 1996 provides an appropriate disclosure regime, remember, it's that simple test from section 3.1. In practice, the system was not working as effectively or efficiently as it should. At page 12, the review refers to investigators and prosecutors interpreting the disclosure test too narrowly or placing too much focus on what the defense asserts to be the case, disregarding other matters unknown to the defense that would be part of the defense case if they were made aware of the existence of this information. So again, we're still not getting it right. It's not working. So, following the Liam Allen case in 2018, very recently, within the last 2 years, a couple of years, we've had the post office scandal in England and Wales, where 900 sub-postmasters and postmistresses were prosecuted from stealing money from the post office because of a technical glitch with the reporting system, which made some money disappear. The post office itself brought many of the prosecutions to court, with the Crown Prosecution Service picking up a few hundred prosecutions as well. The post office themselves were prosecuting one person per week and have prosecuted over 700 people. And the post office themselves were aware of the glitch in the reporting software, the glitch with the Fujitsu Horizon software, and yet they told no one and prosecuted 700 people, many of whom, almost all of them, were convicted. The Criminal Cases Review Commission in England and Wales said that the scandal was the most widespread miscarriage of justice the CCRC has ever seen and represents the biggest single series of wrongful convictions in British legal history. The Post Office were aware of the glitch, aware of the issue, and decided to suppress it, to not tell anyone. They didn't disclose anything, and the vast majority of these defendants were convicted. Some served years in prison. Lives were ruined, marriages destroyed, homes were lost, suicides occurred. Over time, the vast majority, if not every single conviction, will be overturned. The evidence-based justice lab at Exeter University have been looking into the post office scandal. Rebecca Helm and Richard Moorhead in particular have been doing a lot of great work on this. They have a really interesting sort of data collection document in their lab. It looked at roughly over 200 cases. They spoke to 200 people who were convicted of in the post office scandal. Around 85% of them took an early guilty plea. They pleaded guilty at an early possible stage to get a discount. And in this box, for those who pleaded guilty at an early stage, there is like a drop-down rationale. On the basis of legal advice, the prosecution's strength of the case, I've entered a guilty plea. So your legal advisor is there to protect you, is there to advise you. They cannot give you complete advice when they are operating on an incomplete partial fact or incomplete picture of fact. Because if the legal advisor was known about the faulty reporting system, those people wouldn't have entered a guilty plea. They would have contested that. I would imagine the vast majority of them would have contested their case at trial. So your right to legal advice is extremely damaged in terms of what it can actually do for you by disclosure failings at the early stages. Disclosure and fairness, to sort of start wrapping up. Disclosure is fundamental to justice. The original idea that prosecution disclosure was designed to eradicate the inequality of arms between both sides is fundamental to justice. Proper and full disclosure means proper legal advice, because you cannot advise on a partial picture of facts. The purpose of disclosure is relatively easy to comprehend and understand, and ultimately I don't think it's controversial in terms of the prosecution's obligation. But we can't ignore the fact that the prosecutor has a great deal of stuff it needs to consider. The content of computer hard drives, mobile phones, SIM cards, text messages, WhatsApp, email servers, content of social media, CCTV, body-worn cameras from the police, financial data. There is a lot to consider, but the test nevertheless is simple. If it undermines the case for the prosecution or assists the case for the defense, disclose it. If in doubt, disclose it. But there is a raft of problems that arise in the practical application of this area of law. I think proper sanctions are needed, in particular for prosecutors, but for defense lawyers as well, when you fail to comply with your disclosure obligations. I think it's really interesting, I'll touch upon this next week in my talk, is the criminal procedure rules, disclosure from the CPIA in 1996, all about this fostering this culture of cooperation. Right? We're going to achieve just outcome. And yet the police in England and Wales are too ready to, or readily accept that they have the right person because they've arrested them. They are ready to construct a case of guilt and ignore exculpatory evidence and sometimes bury exculpatory evidence. So we have this pressure to cooperate between both sides, and yet we aren't expecting or compelling the police to also buy into this notion of cooperation. This managerialized idea where things can move as swiftly as possible, but the police are still adversarial in nature. Disclosure is here to stay. We're not going to go back to the regimes that you have in Hong Kong, where we don't have any defense disclosure. But until the practical application of the law is improved, and there is a culture shift from all involved, miscarriages of justice will also be here to stay. What do I think the future holds? Well, the criminal justice system is now designed to be economic, efficient, ultimately as swift as possible. I think that there has been a slow and deliberate attempt to marginalize the role of the defense lawyer in its classic adversarial sense and provide justice on the cheap. The changes to the defense disclosure regime are the catalyst for this culture change. Ultimately, adversarialism in England and Wales, I don't think exists any longer. We are in a process or a regime of managerialism that focuses on savings around economy, efficiency, and effectiveness. But I think we forget about the effectiveness. We are concerned with economy and efficiency. The rest of it, we're not that concerned with. There's some further reading of some of the work that I've done. I will send the slides to Simon so we can disseminate them around. Thank you for your attention.
Thank you very much. Really, really interesting. Maybe I can kick off with a few questions. We've got lots of time for some Q&A. So Dr. Johnston, are you saying at a level of principle, this so-called cooperation aim or goal is incompatible with basic principles, presumption of innocence, privilege against self-incrimination in what is supposed to be an adversarial system?
Yes, I absolutely would say so. I think if we think about sort of classic adversarialism, you know, the golden thread is it's for the prosecution to prove their case against the defense. And I think there is far too much assistance in terms of the efficiency forms, the defense case statement, to truly say that that sort of core adversarial tenet of the privilege against self-incrimination can remain today. Yeah.
Okay. The second question I have, those magic words undermine the prosecution case and assist the defense, which you referred to. I guess it's in the legislation.
Yeah.
I've always thought that something else is missing. A third thing is missing, which is to evidence that may suggest or evidence that may undermine the defense case. Did it ever occur to you that should be there? It should be part of the scope of the disclosure obligation?
That's interesting. It's certainly nothing that I sort of considered before, but I guess if we are thinking of the disclosure regime as a reciprocal sort of process between both sides, then it would make sense for evidence that the prosecution are going to rely on also be disclosed as well. But that's certainly nothing that the prosecution are compelled to disclose currently.
The classic example of that is, let's say you have alibi witnesses, and then but the prosecution, the police, they have evidence to suggest that the alibi witnesses are not credible, or evidence to undermine their evidence. I don't think that's within the disclosure obligation, isn't that right?
If it doesn't undermine the prosecution's case, if it just strengthens it, no, you wouldn't have to. So your powder would be kept dry at trial for that.
Yeah. It seems that that's wrong, I think.
Yeah, I would say so, considering the sort of volume of material that the defense has to disclose. It would be right that the prosecution should disclose this too.
Well, we have reached the time, and I've often said that the Hong Kong criminal justice system is like the sort of 1980s, 1990s UK justice system. And hence, we often look to see if all these reforms, we should migrate them here. But I think, Dr. Johnston, your talk has given us really some food for thought as to the wisdom of some of these reforms. So thank you very much for that. And can I ask everyone to join me in showing our appreciation